I think stage is over to you, moderators.
Good
All
afternoon,
the delegates, please be seated in the hall. The panel is about to start.
Good afternoon, all. It's a really an amazing moment of time and cherished memories that we are hosting today at IMA NANDED. Law, order, doctor and everything at one place, which is going to give a complete solution. So, जसं एक आनंदगडे इकडे तिकडे चहूकडे, this is the feeling we have. And with the immense pleasure, ladies and gentlemen, today we have an immense guest, SP NANDED, ABHINASH Kumarji. We have advocate, we have the senior retired judge, we have the esteemed doctors in this panel. Now, looking at the Dr. Ganesh SHENOY, who is a senior doctor and advisor, everybody has been blessed with his talk, and we cherish the memories, sir. You go on talking and we go on listening. But still, at the end of the day and end of this conference, everybody has a feeling that whatever Grace has said, भय इथले संपत नाही, तू शिकवत राहा संध्याकाळी. अशा प्रकारची एक फिलिंग आहे की तुम्ही कितीही सांगितलं तरी एव्हरी पेशंट इज अ डिफरंट अँड एव्हरी मेडिको लिगल आस्पेक्ट इज अ चॅलेंज. सो विथ दिस काइंड रिमार्क आय विल हँड ओव्हर द माईक टू डॉक्टर Kadam sir for introducing the guest of the evening.
The purpose of this panel discussion has been already reiterated by Dr. Anjali. Now, the panelists who are contributing to this session are the great ones in the state, in the medical field and in the administrative field. I first want to introduce Mr. Vijay SIKCHI sir. He is a retired judge and he is having vast knowledge in the medical field, and all the cases related to the medical field has been attended and has been delivered by him. We all know the ABHINASH Kumar sir, very efficient Superintendent of Police NANDED. Again, his another thing is that he is half of the medical fraternity person, because Mrs. ABHINASH Kumar is a radiologist, and therefore we are having every right to call him here. Yeah. And we all know Dr. SHIVKUMAR UTTURE, who is a very well-known personality in the field of law as Medical Council, National Medical Commission and Indian Medical Association is concerned. We are having a senior lawyer, Mr. JAHAGIRDAR, who is an advocate, especially in the field of these medical cases and all. We just listened to him, and who is continuously working being a doctor, and he has come to lawyer, Dr. SHENOY, and he has delivered a very nice lecture. Therefore, the panelists, they are very good in this panel. The purpose is that the teaching in the form of taking lecture and in the terms of theoretical discussion, but the panel discussion is that it gives an opportunity to the panelists as well as to the moderators and the listeners to ask the questions of their mind and get the answers from the panelists. Therefore, I welcome all these panelists who have traveled from corner of Maharashtra here to talk with you all. Thank you, Anjali.
So with this, I will hand over to Dr. Shilpa and Namita. Please.
Hello. Good afternoon, everyone.
Yes, I will request you to give a short introduction and from city so that everybody knows.
I am Dr. Nikita Patil. I come from Nasik. I am a consultant anesthesiologist doing my freelancing practice for the last 16 years. I am actually not trying to waste your time, but we are very much interested in this topic. So both of us have traveled all the way from Nasik to learn from all of you. And it's a very special event for all of us. Now, actually, I will just say, सब कुछ सीखा हमने इन 2 दिनों में. अब सीखनी है होशियारी. So this panel discussion for us.
I am Dr. Shilpa Dayanand. I am general surgeon, and I have been working with Nasik Municipal Corporation in various capacity, starting from casualty medical officer to medical superintendent to assistant medical officer of health to city tuberculosis officer to handling the Divyanga department to all the spices of corporation and the law I have been through. But as it was a fantastic 2 days thing, and actually We are looking forward for more. Thank you very much for giving this opportunity.
Thank you, madam. Myself, Dr. Rahul Lavekar, a pediatric surgeon as well as secretary I am in NANDED. I think this is the epitome of this conference, the most interesting session of interaction with police, judges and advocate to gain and understand the knowledge and fallacies and intricacies of the medico-legal issues we face in day-to-day life. Thank you.
First, we take an audience poll. How many of you are by choice attending this session? Sincere and honest hands up. Very nice, very good. And how many of you are here out of compulsion that I should know this subject? To know the subject and the laws. So on the same note, my first question which we practically faced to Dr. SHENOY sir, in my hospital or whatever premises I'm working, I advise for an injection. And the sister goes and gives it. And suppose it is a wrong injection she has given. Or I can also say the pharmacist in my hospital has dispensed a wrong drug. How much I am involved and how should I deal with this, sir?
This question can be answered on two folds. One is civil liability and one is criminal liability. And this involves the subject which is known as vicarious liability. There is something known as law of torts. And in the law of torts, there is a chapter on vicarious liability. And the chapter of vicarious liability, the word used is respondent superior. That means whenever there is a liability cast, let the superior person respond to it. That means what? That means whenever there is a relationship between two people, which happens to be employer and an employee, or a principal or an agent, for all problems created by the employee, or for all problems created by the agent, it is going to be the employer who pays compensation. It is going to be the principal who pays compensation. I'll give you a very simple example. Nurse, a very old man, 80-year-old man for a herniorrhaphy, surgery, you say half an hour prior to the surgery, give 1 ampule of atropine, and instead of atropine, the nurse gives 1 ampule of adrenaline. You know, both of them look identical. Oh, color deke, give it. The moment adrenaline is given to an 80-year-old man, he expires. Now that death that takes place has taken place at the hands of a nurse, correct? Yes. The problem is at the hands of the nurse.
Yes.
Now this problem can be tackled in two ways, I said. Civil liability, the hospital owner becomes accountable to pay compensation for this act. But then if hospital owner were to pay for all acts or omissions on the part of the employee, the hospital will have to close down. The law is not that bad. The law says the hospital owner has to pay, but the hospital owner can always recover the amount from the erring employee. But this recovery has got to be done in installments. It cannot be immediately recovered. It has to be done in employment. Now, when it comes to criminal liability, the law is different. And I've always said, in criminal liability, there is no such thing as vicarious liability. The person who does the act is accountable for the act. I'm telling you a very simple example. I've got a nursing home, obstetrics and gynecological hospital. I deal with women. I have to keep ward boys because heavy jobs have got to be done by ward boys. One fine evening night, one of my ward boys rapes a patient. Now this becomes a criminal act. Now for this criminal act done by the ward boy, does the owner of the nursing home, Dr. SHENOY, go behind bars? Answer is no. Okay. When a criminal act is done and it is identified as to who has done it, this particular person will have to bear the brunt. Vicarious liability does not become accountable. But there is a situation where in criminal law also vicarious liability becomes accountable. It's interesting. See, I tell you, there is a hospital known as Amri Hospital in Calcutta. There was a big fire there. Do you remember? Big fire, as a result of which evacuation of the patients was difficult. Many patients were charred to death. Here what happened was, it could not be identified as to who was responsible for that. In such situations, the directors of the hospital were picked up. It was a, trust hospital, the trustees of the hospital were picked up. So, indirectly, if at all, the person cannot be identified in criminal law, then the accountability will be definitely with respect to people who run the hospital. Correct me if I'm wrong.
Sir, I have a question to...
See, remember, if it is a state-owned hospital, the hospital administrator or the dean does not become liable. Remember, in civil law,
Sir, that's what we wanted to ask.
Tell you, in civil law, suppose the hospital is owned by the government of Maharashtra, and the dean is appointed by the government of Maharashtra. If there is a problem and there is a liability in civil law, does the dean pay? Answer is no. It's the government of Maharashtra who pays, because respondent superior means the owner of the hospital will be accountable.
Sir, then what about the vicarious responsibility of a medical superintendent of a government hospital?
No, you will have no vicarious responsibility. It is always the government of Maharashtra. That is why government of Maharashtra has always made a party in such litigations. Sir, correct me. Jahagirdar sir.
I have a question to SP sir. Taking forward the same case, the nurse has given wrong injection mistakenly, the complication has occurred, or you can say death. The relatives have gone to the police station and they want immediate action, arrest or FIR onto this thing. So how, from police perspective, the police looks at this scenario for the hospital or the doctor?
Thank you so much for inviting and asking this question. I believe in mistakes or the criminal liabilities done by the hospital administration or from the doctors, we in general follow a thumb rule in which any act of medical negligence, be it intentionally or negligently, has to be by a committee first. We have many cases where, for example, Jacob Matthew cases and all, where it has been amply made clear that any case of medical negligence has to be approved and clarified, and then only we take cognizance of it. Otherwise, we refer the matter to the concerned agency, concerned committee, and then only we take the matter into cognizance. But we, in some cases where that has happened, we do register 174 accidental death case. And then based on the committee report, we'll proceed whether it's a negligence act or bona fide mistakes or whatever the committee has recommended. But at the same time, as sir was saying, in principle of law, there is, in criminal law, what we follow, there are two principles: mens rea and actus rea. Mens rea means your intention. So we also see in, as the example showed by Dr. Saab also, that whether the intention of administration is there in the whole criminal act or not. And actus rea means the action conducted. Mens rea is the intention and actus rea is the action. So if both are there, we'll take cognizance of it very surely, but we'll wait for the committee report. But in criminal part, these two plays almost equal role, that actus rea and mens rea. So whenever, as sir was saying, we were discussing in the earlier case, that if any person or higher administration is not directly involved, and as in this case, the injection was given by the nurse, but if the knowledge is there that this kind of mistake may happen, and adequate training has not been given to the staff, and a kind of intention to save cost or something is there on the part of administration. So knowledge and intention, if it is there, then we have some sections in IPC, which now is BNS 34. So it's a common liability, which actually कि सब मिलके किया है, इनको पता था, इनको knowledge था. But ये far-fetched conclusion होता है, इसको proof करना बहुत मुश्किल है. So in that cases, higher administration can also be taken into account, but it all depends on the recommendation of the committee. Thank you.
Thank you, sir.
Question, sir. Same discussion to be continued. Suppose we have a bad time. ABHINASH Kumar ji is not the SP at NANDED, and some different SPs there. And I get a summon that as a hospital owner, I am receiving a summons from the police station. So my question to Jahagirdar advocate, sir, that in such situation, when I receive a summons from a police station, what should I do next?
First of all, you have to appear before police station. You have to appear before the police authority who has summoned you. वहाँ पे जाके वहाँ after going, what they want to, what information they want from you, it is to be delivered. It is to be told to them.
But what about now the primary feeling of a doctor when he receives such summons or a letter from a police station that I will be behind the bars? That is what. So what safety measures we expect? Suppose I come to you, or suppose I call Dr. SHENOY as an advocate. So what should be the next emotional satisfaction so that I am safe, I am not directly a culprit of the event?
No, if you are not directly involved in the incidents, and already sir has told you that if you are not involved, but some informations you may have, that information is to be given to authorities.
Okay.
Authority, that is police, is a investigating agency, and medical negligence or medico-legal, this ambit and ambience of medico-legal is very vast. Whether negligence is there or not, that is to be find out.
Okay.
And if you have not done it,
any other answer from UTTURE sir in such situation?
No. Once the police summons you, you have to go. There is no other way out for you.
Before that, we will go there, no doubt.
Only thing is, see, you already know there is a death caused. Once there is a death caused, there can be chances that some action is going to be taken. So I think the best part at that time is, whoever is your lawyer on record, it's better if you can request him to go with you plus one family member. Don't go alone. Don't go alone. Go with one of your family members and your lawyer. I think that would be a better bet for your safety than trying to go there alone. That would I do.
Right.
Can I take this opportunity to be on both the sides, since being an IMA? Because sir has opened up sort of a Pandora's box, sir. And this is a question to both Judge Saab and SP Saab. You spoke about mens rea, right? Now, any death, medical death, is an accident, because there is no intention of that doctor ever to kill that patient. So if you go with that thinking, I think any of these death, of course, unless there is some gross negligence of omission, commission, whatever, but accidental death, if there is no mens rea, can we really put, because what the judiciary and even what the police say is that if there is a death, this is going to be a criminal offense. So is every death a criminal offense, or you are going to accept that mens rea concept is there and that doctor is not responsible for that?
Yeah, the answer is very clear. There is no doubt that all the deaths are not, does not have any criminal involvement in it. In the sense, obviously all the deaths will not be a criminal case. There are natural deaths, there are deaths which cannot be avoided, even if you try whatever you can. But there are deaths which cannot be avoided. But wherever my intention of saying that the mens rea is also important was in general principle. In criminal acts, we try to assess both the things. Not particularly to this, cases of MLCs or medico-legal cases, but in general, in IPC, CRPC, we see both mens rea and actus rea. And definitely, not all the murders will be having criminal component associated with it. Unless until, there is some negligence, unless until it could have been avoided, and where the death has happened, in such cases, there will be some, inquiry, in some cases there will be some police action also involved to it. So this was answer about this question. And the question of madam, that if the summon has happened and someone has come, what should be the response of it? We should be very clear, police does not have power to summon. Police can only give you notices. Summon is generally given by the court. Court gives summon, we give notices. And in some cases where you do not have the clarity that for what this notice has come from police, you can actually ask in written or in orally also that please specify what actually information that you need. In general, notice if it has come that this FIR has come and you come to police station, then you can actually go ahead and ask that what specific information that you need, what specific document that you need, what specific record that you need. I'll come prepared with that document. So ideally, you should actually go to police station without any fear that if the police has called, there will be some need of documents, there will be need of your statements, but not, police does not call only for arrest. They call, in many cases we call so that we do not have to arrest. If you cooperate with it, because we have limited space in our lockup also. I'll tell you.
That is what the primary feeling was, sir. Very nice.
There are practical, logistical limitations to that also. We have been barred by courts also. Respected judges are here. We have been barred by the court also. We have been barred by the respective, many judicial and verdicts are there, where we have been told that police should not arbitrarily arrest to anyone. Arnesh Kumar judgment, for example. It's very popular judgment from where Article 40, Section 41A, there we should ideally give notices unless until the complainant, the accused or the suspect does not cooperate with us, we will go ahead with arrest. Or if the criminal act is very severe, we go ahead with arrest. Yes.
Sir, sorry to interrupt. I am Professor Dr. Rajesh Tere. I am head of the Department Forensic, and 28 years I am in this expertise with teaching. It is not always that, sorry to say, police will call you and not arrest you. I can give names also. It may be rarest of the rare. We agree with this. So that is always there. It is not only the allegation of negligence. Along with allegation of negligence, there are some allegation of tampering of indoor papers and rewriting and tampering and forging the documents also. So for that sections, I think it's a cognizable section. There are few reported cases in Mumbai which they are called diligently with due respect, and they, after due procedure, they are arrested. So whatever I think UTTURE sir has said, it is always to go with one of your relatives or your counsel representing you, being your fundamental right of representation. This is one of my suggestions. Secondly, just I want to ask Dr. SHENOY sir, also Honorable SP, in the present scenario of this case, we have only discussed about respondent superior or master respondent or vicarious liability. In same case, I am not changing the case scenario. Is there any role of act of omission and commission read with sections of IPC 201 and 202 in this same case? Thank you.
You want me to answer?
Because he is investigating the case. You are medical legal expert on the
See, the question of arresting a doctor as to when the doctor has got to be arrested has been discussed very well by the Supreme Court in 2 judgments. I'll come to your topic. I'll exactly tell you when, how the liability comes in. In Jacob Matthew is one, and another judgment by the name of Martin D'Souza. In Martin D'Souza versus Muhammad Ashfaq, the Supreme Court has once again discussed this. The Supreme Court in Jacob Matthew has been very clear and has identified what falls within the ambit of criminal liability and what falls under the ambit of civil liability. I'm coming to your question. Now see, it says the criminal liability will start the moment there is something known as gross negligence. And when there is no gross negligence, the liability will always be civil. Therefore, the question is, what do you mean by gross negligence? gross negligence, this particular term, has not been defined by the Indian Penal Code, remember. So the Supreme Court says, gross negligence is that kind of a negligence which a reasonable prudent doctor in his wildest of dreams or imaginations will not do. What does this mean? I'll give an example. Law is very difficult to understand without examples. I'll give you an example. It goes right inside. The first thing is, suppose there is a homeopathic doctor and he feels I'm such a beautiful doctor, so well-versed doctor, so well-read doctor. He goes into a neuro theater and he does a craniotomy and the patient is bound to die. Correct? So a homeopath doing a craniotomy is unthinkable. It cannot happen in the wildest of dreams. And when it happens, it becomes a criminal liability. Are you understanding me? But when a neurosurgeon goes to the theater and does the same kind of operation and the patient dies on the table, that can never be criminal negligence. Maximum is, if at all it is proved there is deficiency in services, it can be civil liability. Now, Jacob Matthew also very clearly states that when the doctor comes to the police station to record a statement with respect to negligence, I'm not talking with regards to tampering of documents, I'm not talking about that, with medical negligence, the police is not supposed to arrest him until and unless there is an opinion given by a medical board. It's known as a medical board opinion. What does this medical board opinion mean? It means, suppose the patient has died on the table, the police comes, does a panchnama, takes charge of the body, sends the body for PM. Okay? And then the police is supposed to investigate the case. Investigate the case means police is supposed to call all the parties concerned and question them and record their statements. And once the investigation is complete, by the time the PM report also comes, it is supposed to send this entire file to a medical college, to the dean, or to a, wait, let me finish. Dr. Derry, let me finish. Then dean or the medical superintendent, and he is supposed to formulate a board of odd number of people concerning the specialty, and this board has got to go through the records only. They have no business to call doctors, mind you. Remember this. Only go to the records and return an opinion whether there is criminal negligence or not. Here is the problem. Because this medical board gives an opinion with respect to civil negligence which they are not supposed to do. The starting point is police station where criminal litigation goes on, and the medical board is expected to give an opinion whether there is criminal negligence or no. And this, by and large, I've found out medical board does not do. It just says that there is negligence. But what kind of a negligence is not mentioned, that is what requires to be done. Now the question asked over here, vicarious liability. What is the controlling power of the hospital owner over the sister to see that she gives the right type of an injection? That is your question. Correct? What is my liability?
I am not on the respondent superior, I have cleared.
Yes.
My simple question.
Respondent superior is only in civil law.
No.
It does not come in criminal law.
That was not my question at all.
Yes.
My question or my query was, in the same scenario, respondent superior, whether civil, criminal, that is okay what has been discussed. My query was, is there any role of act of omission and act of commission read with section with 201 and 2 in the same scenario? That was my question. So correct. I was interpreting.
Yeah. So it all depends upon, once again, the question of mens rea comes in over here. Whether if at all there was an act of omission or commission, and if there was mens rea behind it. And that becomes very difficult to prove in the criminal courts now. Because the hospital owner has employed a qualified registered nurse who has got the responsibility to check the injections before she gives.
SP sir has to go to Deglur. Therefore, we have to ask the questions first. Sir, my question to you. Post-mortem after the death of the patient is a burning issue in the hospitals. It has been extensively discussed in the yesterday lecture, and I have forwarded you the Wardha Superintendent of Police decision also. And when we have come to you for invitation, at that time also we discuss. Whenever there is, our traditional teaching is that whenever there is a death in the hospital, sudden death or 24 hours, within 24 hours death, and the death occurring due to trauma, due to poisoning, due to snake bite, and if the treating doctor is considering there is some foul play, then we have to ask for the post-mortem. But most of the times the relatives, they are not ready for the post-mortem. We send MLC to the concerned police station people, the relatives goes to the police station and they ask, they are not willing. The police answers to them, ask the hospital to get back the MLC. We will not do your PM. Therefore, the onus lies on the owner of the hospital. Therefore, what will be the solution for it? If there is no any foul play, if the treating doctor is ready to give cause of death and the relatives are not ready for PM, what can be done? And is there any judicial implication, my second question to Judge Saab, whether there is any judicial implication of not doing PM on treating doctor?
Yeah, it's a very relevant question, I think. In many cases, our interaction with medical fraternity revolves around PM, whether PM to be done or not, and the legal issues involved to that. In many cases, PM is not needed and should not be done. This has been said in the judicial verdicts also, and practically also, where the cause of death is almost amply clear. There has been if there is no objection from the family also, victim's family also, if the NOC, they are ready to give NOC and prima facie to police, because we are not medically very, any kind of expert, but prima facie it looks that there is no foul play, there is no criminality involved to it, then we also give NOC. And if these two NOC is there and the cause of death is given by the respective doctor, then there is no need of PM. And as you already said, that many SPs have given clear guidelines that how it has to be done. A kind of flow chart is there. And we'll try to implement that in NANDED also. Because in many cases, it involves, it unnecessarily pains all the three stakeholders involved. The family also, they have a dead body in front of them, and they go around the added trauma of postmortem and the related processes involved to it. At the same time, it adds burden to police machinery also. We wait for the PM and inquest Panchnama and everything. And for medical fraternity also, forensic medicine, the PM who actually conducts the PM, that's also added burden to them, where it is not actually necessary. So if a kind of SOP is derived, and when it is not needed, the PM should not be done, and we'll try to implement that in NANDED also.
Thank you, sir.
Thank you.
Is it on the lines of Vardha you are telling, sir?
Yes, that SP Vardha, Ankit Goyal sir was there, and there are some improvements needed in that also, but it is in that line only.
So let me, because there is a state chapter of Medicolegal Association of Forensic Doctors. I am secretary for 10 years in that. So that we have objected on few points. Because what happens, take one example. Government notification of DMA is a competent authority. Dr. Deshpande was Director Medical Education and Health from Aurangabad. He was also a forensic man. And there is a government notification that in which cases a doctor need to inform to the police. Or in other way we say MLC. In other way I will clarify this. Now in this, take an case brought to any doctor, maybe government setup, maybe private, law is same to everyone. ऐसा कुछ नहीं कि गवर्नमेंट के लिए अलग लॉ है, प्राइवेट डॉक्टर के लिए अलग लॉ है. Within 2 hours, if there is a death, and this is labeled in medical field as a sudden death. Correct me if I am wrong, all luminaries are here. Now in that, say 1 or 2 hours, he is brought in gasping state, that patient. So first duty of any treating doctor is to save the life. And CPR, adrenaline, whatever the emergency required to recorrect the patient and to make it stable or to save the life of that patient is tried for 1 hour, 1.5 hours. And then he or she succumbs. And in this case, doctor is not a court to give a cause of death, even though he feels so. I can give one example of doctor orthopedician from Thana, that he was arrested after 2 years. I will not name because it's not wise on my part. So in this scenario, what I know Dr. Khandekar and everyone, and we have objected him many a time in our society. It is not that everything is wrong in that.
Sir,
It is that
with due respect, SP sir has to leave early, and moderators have framed some primary questions which interest of the audience.
Clarity
So I'll request you to be it. Ha, sir.
बिल्कुल सही है. You got your point, sir. I got your point that in general without any unmindly इसको apply नहीं कर सकते. Got your point.
Sir, because so when we discuss on forum and when we declare something, it has impact on the delegate sitting here. I am not questioning anyone here, neither I am pinpointing anyone. I am discussing what was discussed 6 years before on this. So my request would be, in that there are few points which needs to be recorrected, re-examined and reformulated so that it falls in line with the CRPCs under which we do PM and various notification issued by competent authority in relation to that. Thank you.
Just a minute. It was. I will clarify to. I will clarify to you. We had a meet with SP sir 3-4 days back. We requested him only where we can give death certificate to the patient. There and there only. For example, it is a MI patient brought to my casualty, dies within 2 hours. Cases like those only, not all cases.
Hello. Hello. The question of cause of death differs from person to person and case to case. No any state docket formula can be stated in that regard. If the patient is old age and in normal circumstances, his illness is known, cause of death can be determined from the death in situation in which he died, then the certificate can be issued. But if there remains some doubt regarding the cause of death, or if there is likelihood that some complication may arise in future regarding the cause of death, and there are conflict of the persons attending the matter, then in such circumstances it is desirable that postmortem should be carried out, and so certain cause of death can be determined.
Hello. We all are NANDED IMA members are very happy and feel proud that in last 3 years, in the tenure of respected SP sir, we have not faced any issue, any medico-legal problem regarding whatever scenarios we are discussing here, imaginary, fearful. So we are really thankful to him. Another thing, we met him last week. He keeps on calling all the communities like doctors, coaching class people. So he called us and delegation of NANDED doctors, IMA. And what he told us, we were discussing the same thing, that recently there is an increase in the crime related to financial fraud and all this digital arrest and all that. And I would like him to brief us shortly about these issues. Sir, please.
Yeah, not very related to our present topic of discussion, but just I wanted to highlight there's one vulnerable group which we have seen is generally targeted by such cyber criminals. Those are some of the highly sophisticated professionals like doctors. Even software engineers are being targeted through these because they are not able to give that much attention to what is being done in their financial spheres and all. So generally, there has been cases in Pune, there has been cases in Nagpur, there has been cases in Mumbai, where doctors are specifically being targeted because their numbers in many cases are publicly available. There some of the details are also publicly available. And then they call, and they in between your work, they'll call you, they'll try to give you something like your parcel has come. So one specific kind of crime that we generally see is parcel courier related fraud, that you will be called that your courier has been intercepted and there has been some narcotic drugs or there has been some substance which has been found, and then now you need to verify everything so that it can be released. Otherwise, NCB, ED, CBI, Mumbai Police, Crime Branch, they'll take all the names. And it's kind of, hypnosis, if I may say this word, that gradually you will be, pulled in, and you will be kind of, they say is digital arrest. They'll put you on digital arrest. That means that you cannot interact to even your family members till the time you are interacting with the so-called police person or the law enforcement agencies. And this process will go on for some 24 hours, 34 hours, 48 hours, like that. They'll take your online mobile, this account details. They'll even force you to go out, take your money and go into the bank and transfer to the amount to their account. And till the time they actually utilize the money or take out the money, you will be put under that digital arrest. So particularly I wanted to highlight this issue because doctors has been one of those target groups. Similarly, we have seen many frauds. Courier fraud is one. Second is investment related fraud, where obviously doctors these days have got good amount of money, and in many cases that kind of financial awareness or that kind of time you cannot give in terms of your wealth management or investment management. So they'll tell you, they'll include you in some Telegram group, WhatsApp group, and gradually they'll tell that हम लोग बताएंगे कि क्या क्या अच्छे investment हो सकते हैं, we will guide you and all that. But gradually they'll zero in some of the target person, and then they'll promise you very high returns, very high allocation in IPOs, which generally you do not get. Recently we had Nykaa, we had Paytm IPO, initial public offerings, where you do not get the share generally, but they'll promise you that through FII routes or something like that. They'll use jargons which even they do not understand, but they'll use it. They'll put you in some Telegram, WhatsApp groups, and gradually you will be attracted towards those investments to park your surplus amount. And then gradually they'll show you the return also in one web portal, that your money is growing by 10%, 20%. You have been allocated this share, which is not generally allocated to some other person. And that kind of privileged group you are into, they'll try to convince you, and gradually your big amount of money will be gone into that. Even in NANDED, we have seen cases where almost 70 lakhs of rupees from one person has gone into this investment related fraud. So my appeal would be through this forum to our respected doctors, that any kind of financial investment, any kind of this threatening calls that you will be put under digital arrest and everything, this actually police does not do digital arrest. There is no CRPC provision, IPC provision of digital arrest. No multiple agency call you over telephone and try to interrogate you or try to get your details. No bank even call you for OTPs and all. So all this SIM related fraud, ATM related frauds, digital arrest, courier related fraud, and investment related fraud, we must be very careful, because your time is very precious. You are engaged in high, emotionally involved tasks, and in between that, if some kind of nuisance comes, it's a loss for society also and for you also. And if at all such kind of crime has happened with you, immediately there are fixed SOP for that. There is 1930. There's one cyber crime helpline number throughout nation. You should call to that. We will circulate our cyber wings contact number also. There is one website, cybercrime.gov.in. If you report at this 1930 and cybercrime.gov.in, in what we call is the golden hour. That means if you immediately report it, there are high chances that we will freeze those accounts from where these transactions are happening. And there are high chances that your money will come back. But if you, delay it beyond a time, the criminals will take out the money, and then chances of coming back will be very less. It keeps on decreasing. So try to raise complaints in that golden hour, and there is no fear, there is no shame in it. Anybody, even my family members, can go into cybercrime. We have seen cases where family members or the victim thinks कि अरे मेरे को बेवकूफ़ कैसे बना दिया, अगर मैं रिपोर्ट करूँगा तो सब मुझे stupid समझेंगे, मैं कैसे फंस गया. So there is no shame into it. There is nothing to be ashamed about it. Anybody, even I can be victim in such crimes. So my request would be to immediately raise the complaint, through nearest police station to cyber wing, and we'll try to solve it. Thank you.
How many years I have received this fraud calls?
Digital arrest means nothing. I'll tell you, there is no provision in CRPC in any law of digital arrest. Digital arrest is bullshit. Nobody can arrest you digitally. Arrest can only be done. Now, respected Judge Saab will tell you more. Arrest can only be done physically. There is no digital arrest, cyber arrest, or anything. This is all, if someone uses digital arrest, you should be alarmed that this is a fake call.
One solution for all of us, I would like to ask for a favor, sir. Just as in a flight, when someone presses a bell, the cockpit or the authorities, they know from where this call is coming. So can we have a system even in our hospitals where we just press a button and it goes to the police stations that there is violence here and we need help immediately?
Actually, there is a button. Button is there in your mobile. Call to that number, we'll respond.
Sir, actually, sir, just for the experience, we have police protection been allotted to our Nasik Municipal Corporation, but unfortunately, even after reporting that we are having violence here, there is no response. So, sir, this system should be a routine, like what in our medical language we say that some things happen at spinal level. So, the moment we get that level of protection, I think the medico-legal CMEs will also have less attendance.
Sir, my next question will be, at all times, ABHINASH sir will not be here in NANDED. And now the society, the advocates and the RTI activists, they are knowing that it is difficult to trouble the doctor in cases of medical negligence. Then they are finding the ways in terms of administrative negligence and in terms of 156(3). Therefore, my question to SP sir and J sir, how we should proceed in these cases?
Hello. Section 156(3) of CRPC is the direction given by the court to the police authorities to investigate the matter. If a cognizable offense occurs and it needs investigation, but in spite of taking the complaint to the police station, if it is grievance of the complainant that it has been not dealt with properly, then that person approaches to the court and filed an application under section 156(3). That is the procedural aspect. It is a request made to the court that such cognizable offense has taken place and it needs investigation, but it has not been investigated in routine course. Therefore, court should direct the investigating agency to investigate the matter, and thereafter if the court passes the order, then the process is sent to the concerned police station for taking the investigation into the matter.
But sir, many of the times the doctor, they are not knowing that the complaint is being lodged. They directly go to the complaint to the police station. Doctor is not knowing. If the action is not taken by the police station for a week, they directly approach the court. And it has been happened in our city only. The court has not given any intimation or information to the doctor, and the offense has been registered.
There is no need to, in the law, there is no provision to give the intimation prior to registration of the crime. During the course of investigation, unless some offense is detected, then only the need of the accused or the part of the accused comes into the picture. There is no provision to give the intimation to the accused prior to registration of the offense. role of the accused comes into the picture only after the registration of the offense.
Sir, I want from you about administrative negligence.
Yeah.
Medical negligence and administrative, how it is related to doctor?
This is actually a serious issue. Issue not limited to just medical negligence. 156(3) has been a cause of worry, with all due respect to respected judge sir. 156(3) has been a cause of worry for us also in many cases where we are certain almost in our chauksy, what we say in Marathi, in our inquiry in many cases that we see that the case is false, and we deny registering such cases on the basis of our inquiries. But then in many cases some samajik karyakarta, quote unquote, and then many such karyakarta go to, they have this forum and right also to go to court, and they come with 156(3) and we have to register the cases. I know the intent of 156(3) is very noble and should be given, where in many cases police has also committed mistake of not registering bona fide complaints. But in many cases 156(3) or any such medium has been a mode of extortion also. We have seen cases of 156(3) in many schools. In Maharashtra we have many government public aided schools, संस्था, ये सब में वो 156(3) की धमकी देके एक्सटॉर्शन वगैरह करते हैं. इसमें एकदम लीगैलिटी में नहीं जाके मैं एकदम प्रैक्टिकल आंसर बताता हूँ आपको. आई एम श्योर जज साहब ने इसमें लीगैलिटी बताया है, मैं भी बता सकता, अपन डिस्कस कर सकते. बट प्रैक्टिकली इसमें ऐसा है कि 156(3) वगैरह की धमकी से डरना नहीं चाहिए. वी शुड नॉट बी फियर ऑफ 156(3). 156(3) इवन इफ होता भी है तो ये सिर्फ FIR हो रहा. FIR कोई पनिशमेंट नहीं है. FIR is just the start of this whole criminal process, and then we will investigate the case. If the case is false, if you are very confident there has been no administrative negligence from your part, if the record keeping are proper, if there are proper medical and administrative record maintained in the hospital, there is no need to worry. 156(3) में सिर्फ केस रजिस्टर एट मैक्स हो सकता है, बट इन्वेस्टिगेशन के टाइम हम लोग केसेस क्लोज करते हैं, जिसको केसेस फाइनल करना बोलते हैं. A, B, C ऐसे 3 कैटेगरीज आर देयर वेयर वी क्लोज द केसेस. इफ द एविडेंस द केस इज फॉल्स, many a times we close the case with B final. That means we are not submitting the charge sheet, we are closing the case saying that this FIR is false. Even in cases, many cases we provide A final to FIRs, where we say we are not able to gather evidence, so we are A finaling the case. So my point is, even if in worst cases, even if the FIR has been done, and if your record keeping, your practices are proper, there is no need to fear. In any case, as we discussed, the chances of arrest has been lowered down. अभी तो हम लोग ऐसा हो गया criminals को arrest नहीं कर पाते. Exactly, this is the actual, in many cases, because of courts, they have said where the punishment is less than 7 years. In such cases, we should not ideally arrest the accused. इसलिए आपको लगता होगा कि चैन स्नैचिंग वाले ये इतने क्यों घूमते रहते. हम अरेस्ट करते, वो छूट जाते या उनको बेल हो जाता. In smaller cases, we cannot arrest them. We generally give them notices. So my point is, there is no need to become very apprehensive or fearful of FIRs. Even if FIRs has been done, there are checks and balances, there are safeguards meant in the system itself where the doctors will be protected. And in such cases, police also understand that the case involves professionals and there is no need to arrest them. If they are cooperating in the investigation, they are providing all the documents are proper, we try to close the case and we'll do that. Thank you.
थँक्यू सर. मला जज सरांना एक क्वेश्चन विचारायचा आहे, ऑडियन्समधून आलेला आहे, की जेव्हा एखादी डॉक्टरविरुद्ध केस चालते तर ज्युडिशियरीमध्ये त्याला अक्युज्ड आहे किंवा नाही, किंवा कन्व्हिक्ट हे करण्याआधी कुठल्या पर्स्पेक्टिव्हनी, कुठल्या बेसिसवर केसची तुम्ही हे करता ॲनालिसिस, म्हणजे मेडिकल रेकॉर्ड्सवरून किंवा एक्सपर्ट ओपिनियन?
Every criminal case is to be decided on the basis of evidence. It can be primary evidence, it can be secondary evidence. It can be oral evidence as well as it can be documentary evidence. What sort of offense is there? If offense is related to the forgery of the documents or cheating based on the documents, then documents will play the primary role in that. If a investigation is in respect of, the trial is in respect of the happening of a particular offense, wherein the evidence of the eyewitnesses is material, who have seen the crime happening, then in that case, the evidence which has come before the court regarding the mode and manner of the happening of the incident, that will prevail over other aspects. So, in each case, it depends what is the nature of the case, how the evidence is collected, nature of the crime, and thereafter, considering all aspects and material placed on the record, the evidence is to be ascertained, and thereafter it is to be scrutinized.
Sir, in the same respect, is there any fast track possible for the doctors? Because it is not the thing whether I will be arrested or not. It is the mental trauma through which we are going through this process. So, is there any process of fast track for the...
There is no separate procedure provided for the any specific case. But if a case is serious or if it needs expeditious hearing, then request can be made in that regard. And if the aspects are considered, and the matter can be taken up for the hearing earliest.
Sir, my question to UTTURE sir, SP sir and Jay sir is that some non-emergency patient is admitted to the hospitals. The relatives are not good. The patient is admitted for 3 days. They have not paid a single penny. Patient is non-emergency. And the patient, he is not paying. How the doctor should proceed for the further treatment? Is there any provision to inform it to the police or district administration, or can the patient should be transferred through district admission to the government hospital and doctor can be saved? I'm talking about non-emergency patient.
Yeah, I think in my talk I had already touched upon this point. It is coming in the new code of ethics which is going to play. In the new code of ethics, it is specifically written that if the patient does not pay you whatever your charges are as per the norms, then you have got a right to jot it down on the Indo paper, send it to the local administration, and then transfer the patient to the government hospitals. But as of today, we are under 2002, in which this has not been mentioned. So you will have to wait to transfer this patient till the new code comes into play.
As far as police is concerned, non-payment of fee does not come under our purview. It's a kind of civil contract that you have entered into to give some service, and the payment has to be done. But non-payment of service as such, when the patient is already in hospital getting the service, does not come under the purview of police.
That is the practical problem. If patient is admitted without taking fees or a monetary return in advance from him, and if he is not paying later on, then some civil liability may arise. That can be done by way of recovering the amount. But the patient, if want to be transferred, that can be transferred because he is not paid, he can be referred to the other hospitals.
Sir, my question is, since last 2 days, the importance of consent and documentation is so important, it's been told. But practically now it feels that consent cannot be severe than the disease. Like we should not be trapped medico-legally, so we are asked to take such a long consent. So my question is, there was a case in our hospital wherein there was a young boy who came with brachial artery injury, and we had to operate. There were no relatives, so we went ahead and we did we repaired his artery, and everything went fine. But if there is nobody to give consent, then how to proceed? Is there any other law for it, or how much doctor can be in the soup if in such conditions?
I think that is also very clear as far as the code of medical ethics is concerned. If it is a life-saving or a limb-saving surgery, and there is no relative to give you consent or anything, and the patient cannot give you the consent, you can definitely go ahead and operate on that patient. To be completely on the safe side, which I think in my lecture also I said that you take the signature of another doctor of that same field whoever your colleague is, stating this is, just like how in Gynec they do that. So you can do that much. That is an extra safety. It is not a must, but it's an extra safety. But if it is if it is a life or limb saving and you do not do something for the patient, you will be hauled up. It's the other way around. So you have to do it if it's a life saving. This is the Supreme Court judgment is there.
Another question is, in this era of artificial intelligence, if some complications do happen, who is to be blamed? The doctor, the robot, or the software company, or whom?
I think very, very pertinent. And just 2 days back, I was in Pune. The Symbiosis Law University has been given by the central government to formulate rules, regulations as far as AI in healthcare is concerned. And we had a full day's discussion. We have come out with some points. And as of today, there is nothing governing AI in healthcare under any law, act, anything. Okay? But definitely these rules, regulations are coming, not in the immediate future, because AI is also in a very nascent stage. Today, we also don't understand how much the AI can do, cannot do, and everything. But those laws are coming. The only law is data protection law as far as AI is concerned, which is in place as of today. But as far as AI is concerned, what you are saying is right. Suppose a patient comes to me with the symptoms, I go on to AI platform. The AI platform says that this is appendicitis. But my clinical judgment says this is a typhlitis. Now, who is right and who is wrong? Suppose I go according to my judgment and it turns out to be appendicitis, I may be in soup. If I follow AI and it turns out that it's a normal appendix which I have removed, then I am in soup. So yes, these rules, regulations will be in place, but as of today, it is not in place. Therefore, as of today, you get precedence over AI as a clinician, and you will be responsible for whatever actions you have taken.
My last two questions will be there. For UTTURE sir and sir. Sir, there are different decisions by different medical boards. One medical board gives clean sheet to the doctor, second makes him accused, third gives clean sheet. How to proceed?
Ask the judge. Yeah, I think this has happened. This has happened.
That's why.
And the same thing happens in any other judicial, this also, in CPA it happens so commonly. The state council gives you that the doctor is negligent. Then you go in, the district council, you go to the state council, they say no, that our doctor is not negligent. Then the patient goes to the national council and says it is negligent. Yeah, boards, yeah. So same thing happens over here. Also, unfortunately, whatever, as far as the judiciary is concerned, Boehm's test used to be what, up till even today, I think you all are following the Boehm's test, whenever you all want to find out it. But after Bolitho has come into play, it is left to the judiciary to decide if they should take the judgment of the board or not. So ultimately, it all boils down to what the judge feels, who is right, who is not. If you have such disparaging, judgments from two boards.
Sir, in the same continuation, you must be knowing there is a recent case of one post-operative death of a child in, so in that the one board gave different opinion and held the doctors guilty. So why this should happen when this one board has acquitted?
The fault is with our boards then somewhere. Definitely the fault is with our boards because, see, means you cannot say purely boards. See, the boards go according to what the document is submitted to them. The boards are not allowed to call or they never call the doctors for this. So it's not like how we hear it in the council where, both the parties are called and this. So therefore, the documentation is extremely important, what you have written down in the documents. If your documents are proper, definitely the board will give you the proper judgment. If, we are unfortunate it is, but even today after so much of such medico-legal conferences and all, we are still so reluctant to write our daily notes and everything in detail. We leave it to either a registrar or to, that assistant or someone to write. And that is where we land up with problem. Even simple things like taking consent for a surgery. We don't take it on our own. Though that's why in my lectures I always say that the surgeon should be the last one to sign on that form before he goes for the surgery. Because when you sign on that consent form, you see to it that, everything is filled. Dr. Kadam will agree with me, there have been so many cases in the council where only the patient's name is written by the sister on top and the signature of the patient is taken down. There is nothing in between, not even what surgery, what complications, nothing is written. So that is inexcusable, I feel, in today's era. Old era that used to be accepted, but not in today's era.
My last question to Jay sir and SP sir is that one young girl is coming with pain in abdomen and vomitings. In the middle of the night, she is accompanied by the neighbor. She is admitted to the hospital. In the due course of 6 hours, she has been deteriorated. When our doctor calls to that neighbor who has accompanied the patient's condition is deteriorating. The neighbor, so-called neighbor, ran away from the hospital. In another 2 hours, patient is gone on the ventilator. We are calling the patient, doctors are calling the hospital, calling the relatives, and next 4 hours the patient died. But when it has the neighbor or accompanying relative, so-called, ran away, doctor informed this thing to the police station. The death occurred after 4 hours of informing MLC to the police station. But when the death is been declared, the parent came to the police station. Parent alleged that there was some family matters, it was a homicide. And the doctor made a conspiracy with the family members, and therefore police should register offense against the doctors. The police didn't interrogate at that time. Police registered the case. The case is been there in the court for 2-3 years. Again, after 3 years of mental torture for the doctor, the case is been dismissed. Therefore, whether the police is at fault, whether the doctor is at fault, and what we should expect from the judiciary.
Again, the answer is very clear. In such cases where there has been no malified intention or there is no malified act on the part of doctors, they should not be named in the FIR itself unless until some board recommendation is there or the report is there. They should not be named in the FIR, and generally it does not happen like that. Generally, doctors are not named even if relatives of the family comes with those complaints. We do not take the names of doctors in the FIR or the hospital administration. But even if, talking purely on the legal perspective, if the FIR complainant is coming with some content in the FIR, we have to take it. This is the kind of requirement from the legal side, CRPC requirement. Whatever is the complaint, we should register it, unless if there is some exception to it. But it will happen in the investigation also, that the names will be omitted out. There are provisions in the CRPC itself to omit those names which are not actually involved and they are not part of the charge sheet. We have provisions like section 169 and all, where those accused or the suspects which are not part of the criminal act, they are taken out from the charge sheet, they are not part of the charge sheet, and accordingly we submit the charge sheet. So in investigation also we can do that.
The role of court always commences when the charge sheet is filed into the matter. Filing of the charge sheet means that a criminal offense has been reported to the concerned police station, it has been investigated, and after collecting the evidence, the matter has been placed before the court for its scrutiny. As regards the procedural aspect, time required for conclusion of the trial of 2 years or 3 years, that is going on due to the procedural aspect. If after procedural aspect completed and after a scrutiny of the evidence, if ultimately it is found that there is no case of negligence has been made out, then ultimate result in the case will be that accused will be acquitted. Then whether the process till the filing of the charge sheet has been dealt with properly or who is at fault in that regard. That cannot be the part of a judgment delivery system. For that, the only remedy available is that if the complainant thinks that he has been maliciously prosecuted and there was no case of criminal nature made out against him, then he can file the case for damages by filing the case for malicious prosecution.
मला जहागीरदार सरांना हाच प्रश्न तुम्ही कुठल्या दृष्टीने बघता याचं थोडक्यात उत्तर आम्हाला अपेक्षित आहे.
जर त्याच्यामध्ये निग्लिजन्स जर नसेल, त्याच्यामध्ये निग्लिजन्स जर नसेल, जर त्याच्यामध्ये निग्लिजन्स जर नसेल तर मग काही प्रश्न उत्पन्न होत नाही. आणि निग्लिजन्स आहे की नाही चार्जशीटमध्ये समजा नाव आलं किंवा वगळलं गेलं तर चांगलंच, पण जरी समजा आलं तरी एव्हिडन्सेस विल बी स्क्रुटनाइज्ड बाय ऑनरेबल कोर्ट. कोर्ट पूर्ण एव्हिडन्सेस पाहिल्याशिवाय, सेकंडरी असो सपोर्टेड एव्हिडन्सेस पाहिल्याशिवाय कुठल्याही प्रकारचं हे होत नाही. त्याच्यामुळे घाबरायचं काही कारण नाही. आणि सरांनी जे सांगितलं की डॉक्युमेंट्स हे प्रॉपरली मेंटेन केले पाहिजेत आणि डॉक्युमेंट जर हे व्यवस्थित असतील तर तुम्हाला काही भ्यायची गरज
नाही. इकडे माझा एकच प्रश्न आहे. There is something called medical negligence where doctors are hauled up. Now here you are telling me that investigative officer has filed a charge sheet. That means his investigation has showed that there is negligence. 3 years the doctor has suffered. Sir, judicially vicharto me. And you find that he is acquitted. Is there anything to take action against the police for botching up that investigation? Because it's not a question that the doctor has been released, it's a question that 3 years that doctor's life has been hell. कारण मेडिकल नेग्लिजन्समध्ये आम्ही अडकतो सर, राईट फ्रॉम डे वन आम्ही अडकतोय त्याच्यामध्ये.
Sir, my question, anyone, judge sir or SP sir, anyone can answer. I will take forward the case enumerated by Sanjay Kadam sir. If that doctor is acquitted from the court after 3 years, can that doctor take the police officer to the court?
Sir has, I think, already answered that you can actually file for the damages. That can be done.
Against the police officer.
Yes, who is responsible for malicious prosecution?
Thank you, sir.
Yes, I think with this great discussion, every great thing and every good thing come to end, and we are end of this session. I think with a great applause, first of all, by the presence and time SP sir has given to the IMA NANDED. Sir, with a gratitude and immense heartfelt thanks, sir. Jahagirdar sir and SIKCHI sir, we are immensely attired and energetic with the discussion that law and order, negligence and medical practice, what and where, this all answers on one forum. This must be the historical event. So please.
Sir, SP sir माझा एक हे आहे. I have a certain concern regarding all the doctors from IMA NANDED that majority of the times police do respond, but some MLCs and some cases the police don't respond timely, specifically deaths and specifically where wrath of the relatives are there. So I kindly request SP sir to do something so that at least a police person take charge of the scenario and situation over there. It do definitely happens in the government hospitals, but in private hospitals, the burnt and crux of the wrath of the relatives goes directly to single person, and that should be avoided. Even if we do have task force, we cannot take the law in hand to do or counteract this. So it is kind request that take something action regarding this, that so as madam has told in some IT manner, but I will say it in physical manner, that somebody should come to us, at least a home guard should come to our hospitals to safeguard us. Thank you.
So with this, the IMA President, Dr. Kotkar, we as a IMA family member are thankful to you for conducting this 2-day session. Secretary Dr. Rahul Lavekar and entire team of the IMA NANDED who are sincerely working since last 1.5 days. And with this, I conclude the session and hand over to you.
Thank you for the wonderful panel discussions. Now I request Dr. Sanjay Kadam sir to felicitate our SP Abhinash Kumar sir.
I request Anjali Dawale ma'am to felicitate Judge Sri SIKCHI sir. SIKCHI sir. Anjali Dawale ma'am for SIKCHI sir.
Now I request
I request Rahul Lavekar sir to felicitate Dr. Shivkumar Utture sir. Jahagirdaar sir
Now I request Dr. Shashi Gaikwad sir to felicitate Advocate Chandrakant Jahagirdar sir.
I request our beloved Masare sir to felicitate our moderators for this session. Sir, please felicitate Dr. Sanjay.
Dr. Dr. Shilpa Dayanand ma'am. Shilpa Dayanand. Dr. Dr. Nikita Patil ma'am.
Masare sir will felicitate all the moderators for this session.
Dr. Anjali Dawale ma'am. Dr. Masare sir will felicitate Dr. Anjali Dawale ma'am.
Masare sir will felicitate Dr. Rahul Lavekar sir. This panel will be followed by the session 7, where we have 3 to 4 lectures. A lecture by Ashish Khatot sir.
Then Dr. Sachin Sandolkar sir.
Dr. Ajay Narayankar sir. And
Dr. Rajendra Tiwari sir.
Thank you all the panelists and the moderators. Thank you so much. Hey, madam.